All right, can everyone hear me? Good afternoon. It's really great to be here, especially among this community celebrating not only CRS at UCLA, but the work of my very dear friend, Jerry Lopez. I'm not going to spend a lot of time telling you about the panelists. It's written in your materials. I won't name names, but one of the panelists said to me after we got together and went through questions, these questions are really too hard, and I want to say...
It was me.
And I just want to say, I want to thank Bill Hing and Jerry Lopez for that training, so blame them. Anyway, we have with us today Marta Gomez, Gina Hong, Dale Manami, and Sunita Patel, all of whom have done transformative work in different settings with different clients. And what I hope we tease out in the next hour and a half is the way in which they not only went about that work, but how they went about that work. And what were the challenges in terms of the communities they were working with, the co-counsel or community members they were working alongside, the fact finders, the challenges of clients, the strategies that went well, the strategies devised that didn't go so well. I don't want this to be a romanticized conversation about the work they did, but a real critique of that work and the communities with whom they did that work. So Marta has done work for many different types of institutions. But I'm hoping in our discussion right now that she will focus a little bit about what it was like to represent Latino police officers in a discrimination case, and also what it's like to try to have fair practices in a place like Bakersfield that were disciplining Latino and African American students at hundreds times the rates of white students. Gina does incredible work in housing and helping to keep people unhoused. But as a part of that work, she and her organization are building a movement and a union. And that's a prerequisite to getting to work alongside Gina. And I want her to talk about the strengths, perils, and fairness or unfairness of that strategy. To my left, I have Dale Manami, often known for his Coram Nobis work on behalf of Fred Korematsu, but today I want him to talk about tenure cases and bringing fairness to Asian professors in the cutting edge of Asian American studies. And then we have Sunita Patel, who is running a really interesting veterans clinic here for unhoused veterans, but I want her to talk about the police case she brought that ended the stop and frisk programs in New York. So with that, I'm going to let Marta start, and she's going to do a detailed critique, and I will be an active moderator and push questions if I feel like it's getting too superficial or romantic. Okay.
Okay, so that's a lot. Can you hear me? Yeah. Okay, so I think that I'll give you a little bit of background. With the Westminster Police Department case, that was a case that involved national origin discrimination against 3 Latino police officers. And so what I will say about that is that a lot of times in the civil rights community, race claims, national origin claims are not as desirable as, for example, the retaliation that happens afterwards. What I've heard is juries really know and appreciate and know how to understand retaliation no matter who you are. If you're a white man who comes forward with a whistleblower complaint, you will experience retaliation. And so there's a tendency to want to focus on the part of the law that is more viable or more easier to prove in litigation, and that you'll be able to get the results and collect on your attorney fees and have that victory. In my view, what that does is it kind of makes race and national origin claims be less litigated. And so if you look through Westlaw and you're doing your research, you may not have as many big civil rights cases involving race the way you used to in the past. One of the things I will say that I was very fortunate working at MALDIF, the Mexican American Legal Defense and Educational Fund, which had a lot of downfalls, is that its mission was fantastic. Its mission was focused on exactly this, and nobody else wants to bring this sort of case. Nobody wants to represent these three cops. Well, we do. And it's not necessarily, people don't necessarily want to be advocating for three cops when you're working in a civil rights org. So there's like this double-edged sword of, who is it that you're fighting for? But from our view, it did seem and it did sound like they were being subjected to decades of national origin discrimination. Every one of those guys was being passed up for special assignments. They couldn't get a single special assignment, like, narcotics, detective, auto theft, other than to patrol the Westminster Mall. That's the only assignment they could get. And everyone else was coming out of the academy, being fast-tracked, getting into narcotics and all of these other assignments that you need them in order as a precursor to go to sergeant. If you want to go from an officer to sergeant up the chain, you needed to have those assignments, and it was never going to happen. So one of the first things that I do have to give MALDIF credit for is, when you're a plaintiff org, you don't necessarily get to conduct a government investigation ahead of time to see what the evidence will show. So you have to make a decision. Do you believe these guys? And are you going to put your resources and your limited staff and your time on it? And so we did. I was put on that case. I don't know if I should say this, but they're like, we don't know if there's anything here. Just do your best, see what happens. And there may not be anything there. And so we worked really hard. In the beginning, it was me for just a couple of years, but then eventually we had to come to grips with this is problematic. The fact that there's such severe understaffing in even these sorts of cases, it's not until things begin to reveal their urgency of like, oh, we could prevail here, that maybe some resources are added towards the end. And Anna will know because she was one of the resources that was added towards the end. But I will say that as the staff attorney, I was beyond my brink of exhaustion, and I definitely needed help way before I got it. Shauna, please direct me if I'm going in the wrong direction. So one of the things that I will say about success in litigation, at least for a nonprofit that was not giving me the resources, was being at the right place at the right time. I went to this conference in New Mexico, and I was talking to Anna, and she was like, oh, I work for a guy who does trials. He does exactly this. And I was like, I'm so overwhelmed. I'm going to go to trial. I've never had a trial. I don't know anything. I have a truckload of evidence, and I don't know what's important. It's all important to me because I got all of it. And so she was like, why don't you have Bernard call you? And so I talked to Bernard, and so Bernard is this phenomenal trial attorney in Los Angeles who does race claims, and not a lot of people do. And he heard the case, and he's like, oh, this is interesting to me. This is the kind of case that I like to do because not a lot of people like to bring them, and I could be the difference maker in it. So we did the whole thing when you want to make your partner think it was their idea, and it's really yours. So we did the whole thing. Like the president and general counsel of MALDIF was like, we're not going to co-counsel with anybody. This is our trial. We're taking it to trial. So then I talked to Bernard. I said, what you're going to do is you're going to come to the office with this presentation. And it's going to be a 2-hour presentation in the Masons room. They're not going to know what hit them. And let them tell you that they, and so we did that. He came and he put together this amazing presentation. And at the end of it, this National Senior Council was like, we're going to be working together. We're going to be working together.
So let me push you a little bit on that. I think I
Tell me.
Turn this. Is it on? Is it on? Okay. On two things. The resources.
The resources.
Why, and you were working at one of the better resourced firms, and why there weren't, you know, in the public, why
Okay.
it was such an apt shot, and the reasoning, which I think I know the answer to, why there was a reluctance to co-counsel.
Okay, those are great questions. So I will say that in 2008, the economy imploded.
Mm-hmm.
So we were not expecting that. When I was going to go to law school, they were like, take the loans, you'll have whatever job you want, don't worry. And then all of a sudden they're like, oh, on-campus interviews are canceled, the economy has collapsed, and go home, there's no jobs. And we're like, okay. So at that time, MALDEF, this was while I was still here, I graduated in 2010, MALDEF had to let go of its staff, a lot of it, and including every staff attorney.
Wow.
So then there was a change in leadership, and I think Nicolas was the first one to come back. He left and came back when there was the rehiring. And then after Nicolas, it was me, so I was number 2 there. So when people would be like, aren't there 50 lawyers up there in the MALDEF office? I would just laugh. I was like, there's 2 of us right now. And so we were kind of creating this shadow facade of like power, but we didn't have it. We didn't have the money, we didn't have the staff, we were barely getting a legal secretary. We had supplies from the 1980s. So it was just not there. And so then slowly every year, I started in 2011, May 2011, and they were hiring 1 or 2 UCLA grads coming on board. But the money was, we were going to be creating the money. Mm-hmm. We had to make attorney fees. Mm-hmm. And so we were at that stage. It was not an easy time. So I will say, the part about the no resources, I think it's a little bit overblown, because I do know that Tom Sines was paying himself like $250,000, and we were getting paid $47,000, right? So there was a disparity in the pay. But with that said, the other thing with co-counseling, once you start to co-counsel, you split the fees, right? So up to that point, every single billable hour was mine. Right? 50 depositions, like it was Victor and myself, the document review. It's just like hours upon hours upon hours. You bring in someone at the last minute to co-counsel, well, what's the agreement going to be? How is the fee going to be split? And so that was like, you guys go to another room and figure that out. I don't care what you come up with, but we're going to have Bernard on this team. Yeah. And so that was the tough part. And it's a big risk, because if you lose, you're not going to collect. But to Bernard's credit, because the discovery had already been done, he just needed a couple of months to learn everything. Mm-hmm. And the risk was something he calculated he could do, given other resources that were coming in, because he's winning trials throughout the year. Yeah.
Okay, keep going, I'm sorry.
No. So I think that one of the things that I will say about the trial itself is that it was in Orange County. Right, the population of who was sitting in it had to be unanimous in a federal court. So picking a jury was very important, because jurors themselves don't believe in race discrimination. And so we wanted to kind of vet that out, and we were very nervous. We got this like Hollywood cupcake lady who was on, we discussed her back and forth so much, and at the end she ended up being fine. But the thing that we saw with, and everyone who's done race claims knows this, the police department brought in every single Latino, put them in a uniform, and put them in the front row of their side, right, like a wedding. And on my side, we had my 3 guys. And so we had people who had said, call me to the stand, I will corroborate that this is ongoing. And then we had people on the stand and everyone looking at them, and they were just fell apart because their lives and their livelihoods were on the line and they weren't in the lawsuit. And so it was a parade of race, the way that race was being used it's so blatantly, right? And if you will allow me to say how we dealt with that, it was hard for me because we had to tackle Latinas. So we had Latinas who were getting promoted to assignments such as Family Protection Unit. That's like domestic violence. And so the Latinas were not interested in participating in our lawsuit because in their view, they were getting some assignments. But the Latino men were not. But I was like, this is a tough place to be in because I do understand that like there's intersectionality and they're actually being discriminated because they're being presumed to be in the domestic violence unit, but they see it as a benefit. So I can't force them to think of themselves as persons who have been discriminated, but I also can't treat them as my ally in this moment. Even though if they call me tomorrow for a case, I'll be like, come on over, girl. That was yesterday. And so for their defense, they called up every single Latino like we thought they would. And they said, let's talk about when you started, your promotion, your position. Well, we were ready for that because we knew that all of that we already had the theory of, this is just, look at the Latinas always go to the domestic violence unit. The white women go to all the other special assignments, right? And when was the first time that Latinas began to have diversified assignments? It was after the date that our guys filed the DFEH complaints and the EOC complaints. So we just had a big timeline. And we're like, this is when the administrative complaints were filed, and then we just populate when that person would say they got their assignment. Boom, boom, boom. Every single one of you guys got the assignments after the charges were filed. So in fact, your promotions and your assignments are retaliation against my guys. And so I will say that is hard because you're kind of they were pitting Latinos against Latinos in the moment. And so that's something that we had to do.
Great.
Yeah.
Before I move on to Gina, one of the salient points that Martha just made is the messiness sometimes of doing this work. I think we think, oh, I'm a civil rights lawyer or I'm an employment discrimination lawyer and everyone's going to be on the same page because we're all people of color and we'll have a kumbaya moment, right? And yet, here, you see the pitting of Latinos against Latinas and Martha's astute recognition that these women need these jobs, they appreciate these promotions, so I have to navigate this really delicately. Anyway, very interesting. Gina, I want you to talk a bit about your work and particularly the requirement that you put on the tenants that you represent.
Yeah, so I can just start off by giving kind of a lay of the land of what work I do. I'm with an organization called the LA Center for Community Law and Action. We're based in Boyle Heights in East Los Angeles, and most of our clients are people in that neighborhood. So most folks are Latinx, mostly Mexican, first-generation monolingual Spanish-speaking clients. And our model is to try and house organizing, community organizing, and lawyering under one roof. The jury is out on whether or not that works. Every year that passes, I'm just like, what the fuck are we doing? But what we try to do is we try to leverage legal support in order to advance the political education and the political growth of the community that we're working with. So what does that mean? That means that we do both eviction defense and affirmative litigation, but we only take on clients who are willing to be organized. So we're not a high-volume legal services organization. We are not LAFLA, we are not ICLC, we are not public counsel. All of those folks are my comrades. We're all on the same listservs. I love these people, but we just have different perspectives on our theories of change. And so what we do at LACLA is we say to folks who come in asking for legal services, we can offer you defensive litigation support, but only if, one, you are willing to join our organization, or you're already unionized or working with another tenant union and willing to put in time to advance the tenants' rights movement. And two, you're fighting to stay in your home. Like if you want a buyout, if you want to just negotiate to leave and displace yourself, you know, no judgment. Everyone makes decisions for whatever reasons they have going on in their personal lives, but there are plenty of other attorneys who can help you negotiate a buyout. That's not what we are able to do. Why? Because I'm one of 2 lawyers, and I've never had a legal assistant. I've never had any type of support staff. So we have 2 attorneys on staff, also a community organizer, and we just hired somebody to do operations support. But it's just the 4 of us in a very small orange house in Boyle Heights, which is my office. It is not romantic at all. We have no resources. But I will say that one of the strengths of having this model is that I was probably the only one in my graduating class who, like, after the first day of my job was like, fuck, I love my job. Like, I hated law school so much, but this is what I was waiting for. And I'm still there. I'm still there. I was the organization's first intern back in 2015 when I was a 1L here. And then I applied to be a fellow and started as a staff attorney, and now I'm the most senior person in the organization. So I've had a lot of my sweat and tears go into building this community, and I do think that there are some advantages. It does mean that I am constantly having to navigate these contradictions, right? Like I don't work in an organization where any of the answers are laid out for me. I work in a place where I'm constantly having to ask myself and my team, like, what is the right thing to do, and we have to struggle together to work through it. Another thing I did want to mention is that we are technically a 501c3, but we really do treat that as just like, that's our relationship to the IRS and nothing more. We internally operate more like a workers' cooperative where we make all of our decisions based on consensus, which is possible because we're 4 people. So I don't know if that's scalable. I'm happy to talk about it. I'm really interested in getting feedback from you all. But you know, so far in the past half decade that I've been doing this, it's really been like a beautiful ride.
Yeah, I had a question, 2 questions. What in your background experience or reading, whatever, research led you to love this type of work? That's number 1. That's personal. Number 2 is what's the rationale between or for having clients have to agree to join a union or a collective organization rather than just a single legal aid type of event?
Yeah, so the personal question is easy. I only went to law school because I wanted to work with organizers, because I was an organizer myself. And so I think I'm already starting from a place where my perspective on how we're going to accomplish change in the world is not through the regnant capitalist white supremacist legal system. Hence why I hated law school but loved my job. So that's really what it was. I did not do housing work. So prior to law school, I was doing political education with system-impacted youth and working on prison education programs in New York and working on solidarity movements across the Asia Pacific against militarization or U.S. militarization of the region. So the housing piece of it was new. But y'all, like, if you don't know about tenant unions in Los Angeles, I suggest you go on Instagram or Google whatever you need to Google, because there's a lot happening. And if I wanted to be a lawyer who was working alongside organizers who are really trying to do like the dirty, messy organizing, housing is apparently where it's at. So that's how I landed there. In terms of the perspective, I think that, quite frankly, we just don't believe that putting an attorney on every single case is going to solve any of the systemic issues. Like broader legal services, I understand Gideon's promise. I have respect for people who believe that, and I don't think that I'm advocating for them to leave the conversation. But I think we need everyone in order to truly impact change, and so our perspective is that what we want to do is we want to develop cadre. We want to develop people who are willing to stand up and who go through the experience of being defended by us and come out changed, a stronger person and with more community. So we tell people, even if you lose your case, at the end of your experience with us, you're going to be stronger and you're going to have way more friends, and we're going to have lots of potlucks, and we're going to be there with you every step of the way. Yeah.
One comment about that is you know, I always believed in the power of organizations and people getting together. And there's always a reason that conspiracy laws exist, because people are afraid of organized activities. And so I totally agree and like that perspective.
Thank you. Yeah.
So I'm going to play devil's advocate a little bit. So what if you have a client, because one of the things you said is they have to be willing to put in the time. And as we know, many folks who are just trying to keep a roof over their head, their children fed, at school, et cetera, don't have a lot of time. How do you navigate that issue?
Yeah, it's really hard. It's really hard. We turn a lot of people away. And also a lot of people don't come back once they hear our prerequisites. But I think really, and I'm really open to feedback and having this conversation, because I think, you know, I'm really interested in what happens at the end of the conversation, because we never get to the end, because by the end someone's left, you know. But for me, it's like, I'm also not feeling sorry for you just because you have less resources than me, right? So that's really the perspective I try to take in my intakes. It's not like lawyers are the only people with regnant ideas. I can't count the number of times someone's come up to me and said, you know, lawyer, save me, right? Literally in so many words. And it's really hard to give someone's power back to them when they've ceded all of that authority to you. But that's part of the work, you know? Like, thankfully, I took rebellious lawyering while at UCLA, and we have all of our staff members read rebellious lawyering, and we know what we're trying to do here. We're co-problem solvers. I'm not here to feel sorry for you and tell you that I need to help you. Not to say that folks who are focused on harm mitigation are doing the wrong thing, right? Because again, I understand that perspective, but it's a question of what do I want to dedicate my time and career to. And also in addition to that, I think also what that question asks us to do is think critically about where we can be more just in our systems, right? Like, so a good example is childcare. Like, offering childcare at our community meetings changed dramatically the type of participation that we get, right? So I think asking those questions is critical, and it forces us to be more diligent about how we can embody the entire organization with just principles.
And can you tell us a little bit more about why tenant unions here in LA are sort of, as you put it, where it's at?
Oh, I don't know, because there's a lot of really rich people with a lot of, it's just the armpit of class warfare every day, my friend. Like, if anyone wants to go and do an ethnography of the eviction courtrooms in Los Angeles, or if there are any, you know, law students who would like to take a ride, it's really just a fantastic display of how it's always really the same moral story. It's always the have-nots versus the people who have, right? I appreciate that moral clarity because it's like the one thing that is clear in my job. So, yeah.
Great. Okay, Mr. Manami, do you want to
All right,
talk
Ms.
about
Marshall.
you want to talk about tenure cases?
Yeah, I really don't. I mean, they're pretty boring. And anytime I get into a law school, man, I start getting nervous because I'm like Gina. I hated law school, and
Yeah, well,
you know,
most of us who teach in law schools today, who are at this meeting, we hated law school
oh, good, good. I used to sit way back there, you know, and the teacher could never see me. But I'm talking about a case that coincidentally was brought against UCLA, and it was a person named Don Nakanishi who was denied tenure, Japanese American. Grew up in East Los Angeles, went to Harvard, then Yale, got a PhD, he got a job in the School of Education, and they denied him tenure. And so and the tenure process is so convoluted, it's secretive, protected by law. There's so many things that, so many places you could get screwed in secret and not even know it and not have a way to challenge it. And so Don, who was an excellent scholar and was supported by some members of his department, what happened was there was kind of a conspiracy by the certain people who didn't like him in the department, and they essentially sabotaged his chances for tenure. Tenure is supposed to be based on your research, teaching, and community service. Well, we know it's really research, you know, that research is everything. And so you could be a terrible teacher, have no community service, and you'll get tenure, especially if you're not a person of color. Because in the school at UCLA, there were a number of professors of Asian descent. All of them, almost all were in chemistry, math, or engineering. There was only one other Asian American in the School of Education. Fortunately, became an ally of ours. So Don's research, which they did, they have these various review committees. You got to go through tons of different reviews. And the dean gets to pick who are the reviewers. So they could pick whoever they want and know that this person will get a bad review. Well, Don did get a bad review, but the thing about the instructors, because I've done several of these tenure cases or professors, two traits stuck out to me, that they are very, very smart. The other part is they're very, very arrogant. And if you're arrogant, you make mistakes because you believe that the law does not apply to you. You leave fingerprints on things. And the first time I learned that as a case I took a deposition of a professor who was in another department at Davis, and this is UC Davis case, and said that, I really wanted this guy to get tenure, blah, 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 blah. And unfortunately, or fortunately for us, we had a spy, and the spy said, this guy is the one who really tried to dump him. In fact, he put it in writing. So I handed him the paper, and his question was not to deny it or explain it. He said, how did you even find that? So, those fingerprints are pretty large. Anyways, so Don came to me, and he said, do you think I should fight this? And I said, well, let me read what you have. And this is kind of like climbing a mountain. I mean, they always have tons of papers. In those days, there were no computers. And they're usually single-spaced. And then you've got to read this stuff, and you've got to learn about why he's qualified. And so you have to learn arcane subjects. I did a case involving the reproductive tendencies of fruit flies. That was at Caltech. That was awful. I hated that case. I had to go to the professor and go look at these fruit flies. I hate fruit flies too. But so we looked at this case, and we realized that the things that were said about him were remarkable. They said his work is not path breaking, even though it's novel. I'm thinking, well, now, is there a word called oxymoron that fits this? And they said several things like that. And it was a rigged system. And fortunately, we had spies in there who told us of the procedural irregularities. So Don was not sure he wanted to do this. To go public like that, to take on, and that's one of the difficulties with clients. And it's not their fault. This is like putting yourself out there and explaining. It's like, the Me Too movement. It's a huge chance to be publicly acknowledged and possibly be branded with different kinds of negative comments. Don agreed to go through with it, but we thought, looking at this, we're like David versus Goliath. This is UCLA. This is a major institution. And big institutions, they don't care about you filing lawsuits that much unless you could use it in conjunction with a political strategy, because they just hand it over to their lawyers, the case, and the case then goes in predictable procedures, because that's the law set up to do that in civil procedure, and there's predictable results. There's very few outliers that you can get huge, amazing types of relief. And so knowing that how powerful they were, we understood that it's all a matter of power and how you wield that power sometimes in a courtroom, but probably better to do it outside of a courtroom. And part of the reason is that it's less predictable. And if you inject that unpredictability into an issue, into a fight, especially against an institution, they don't know how to deal with the unpredictability. Will they sit in? Will they demonstrate? Will they take away our funds? What are they going to do? I mean, if you do put that in court, they know what to do, the institutions. And so we decided the best strategy would go through the grievance process. And they had a set up grievance process, which almost every school has, and it's almost always slanted against the candidate. But this time we got some inside information, which allowed us then to have input. And the reason we got input is because we were able to exert an amount of power against this institution. We got articles published in the media, and I can't understate how important good media coverage is. We put together a committee that included both students and the community. And I think if I had to do it over, I would have strengthened that bond. I would have tried to make it a larger issue nationally. I would have brought in more guns than we had. You know, I'm working in a 3-person firm, and you know, I worked in a nonprofit called the Asian Law Caucus, and that nonprofit work at Asian Law Caucus, I moved into a private firm, but that became a nonprofit private firm. So it was a little difficult because Don's a professor. He doesn't have a lot of money. You know, he didn't invent you know, the COVID vaccine or anything like that to be very rich. And we're fighting UCLA. And symbolically, I mean, you know, we're on Charles Young Drive. He was the chancellor or the president that we had to fight against. And now we're standing here right on the street. So, I mean, that gives you symbolically a metaphor for how much power that we had to deal with, you know, to walk down that street and deal with it. So we needed to have, and the reason we did the grievance too, is that if you file, and it goes back to reprisal, retaliation, they can't fire him. They got to keep him on campus for a while, and you need somebody, and we did in a tenure case, on campus as a symbol, and not only a symbol but an inspiration for the students and the community to know that, you know, he's not out of sight and out of mind. He's there every day, and he's a reminder of the injustice that befell him through this procedure. So, I mean, the students were remarkable. And usually, in my experience with students, no offense to many of you out there, is that once, and this happens several times, you can organize them, but once summer comes, your movement falls apart. Somehow these students kept it together. They were really dedicated and created leadership. We coordinated that with the community groups. And the one thing with institutions, too, by exerting power, one of those levers is to try to go after their money. This is always what I've tried to do with the other cases I did early on in fact, they were always early on, is to cut off funding. And if you can cut off or threaten to cut off funding, you will get their attention. So we enlisted Don. You know, he grew up in East LA, so he had a lot of Latinx friends. He was very progressive in his views, so he had a lot of African American. You know, it was kind of an allyship model for us. So we got the Asian American Alumni Association to try to boycott. We asked other groups, and one of his greatest supporters were Jewish community groups, and they threatened to boycott. In the end, I mean, I can go through, I mean, it's way too long. There's an article I wrote about it. I read it the other day, and it took me forever to read it. And I'm thinking, damn, I sure was wordy. But I'll do an executive summary one day. In the end, we got our friends in the legislature to cut off all funds of UCLA. The chancellor had a pet project, the business schools building, and we bottled up $28 million of his money in a subcommittee through our allies who were liberal progressive legislators and their Asian American associates or aides that worked with him. And when we met with Chancellor Young, then called the meeting because his bill was not going to get out of subcommittee, and we met with him, and he was irate. He said, "Why are you bottling up my building?" And you know, and he goes, "We're not doing this." I feigned outrage because we were bottling up his building, and I said, "You know, this is outrageous." I mean, I was yelling, and because he's like, this guy's 6'4", big, tall, big white guy who's like, just like reeks of power. And he's going to have a street named after him someday. And so we had a huge argument. And then he calmed down. I said, we didn't come out of the prison camps of World War II to become second-class citizens. You're sending us to the back of the bus. We're not going to sit there anymore. So this is going to go on a lot longer than you think. And I'm thinking, oh, God, I hope this is right. and Chancellor Young, who was actually a decent person, he was just kind of, overall, he was just a little bit not paying attention, really, to the demonstrations, the sit-ins, all of this stuff. And he was getting bad advice. There were a couple of people who were advising him, they gave him terrible advice. And he said, okay, I'm sorry, I didn't mean to say that you folks were behind this. These other crazies out there are sure. We go, yeah, those crazies. He goes, Dale, where'd you go to school? Where did you go to undergrad? I said, I went to the University of Southern California. And he goes, no wonder. That's where I met Jerry Lopez. So that's why we've never been back either, aren't we? But that's a different story. Anyways, Don gets tenure. And the bill gets for funding gets released the very next day. And then they announce it. You see, they announced the new director for the Asian American Studies Center, Professor Don Nakanishi.
Oh, wow.
And this is he has since built the biggest Asian American Studies Center in the country. But at the time, after this was announced in the papers, I said, Don, this is great. I'm so proud of you that you stuck it out. I mean, it was really, he'd call every day and leave 30-minute voice. He must have thought he was in lecture hall or something. 30-minute voice messages. And so we would talk every day. And that was straining on relationships I had. It was straining on me. But it was important to keep in touch with him and keep his strength up, because he was in the end, he's the one who's going to suffer the consequences. I might lose a case and become a pariah in the academic community, but I'm not going to lose what he lost. So the only discussion we had you talked about relationships with clients. So I said, so great, what are you going to do? He goes, well, I rejected it. I go, what do you mean you rejected the appointment? You rejected? He goes, yeah, look at. He figured stuff out. He was a smart guy, and he became very political in the process. He said, look, they already announced it. That's totally embarrassing for them to go back. So I told them, you got to give me 2 more full-time equivalents, FTEs, and then I'll do it. So he got 2 more FTEs, and I thought, I got to learn something from this. So anyways, that story. Unfortunately, he passed away about 10 years ago, and his legacy is still around. He's a remarkable guy.
So, see, he feigns that these questions are hard, and then he answers all of them. Then I don't even have to push. But
Yes.
Couple things we want to pull out of this, right? First of all was they knew, given the resources, they meaning Dale and his firm, and it was just Dale on this case, that if you just turned it over to litigation, here comes the UC General Counsel office with, their army of lawyers and loads of money who will out-discover, maneuver you. So by rethinking strategy, right? Grievance procedure, let's keep him in there. Community organizing, let's get the students. This is a guy who's got allies in lots of communities. The Latino community, the African American community, the Jewish community. Nothing like defunding your chancellor's pet project, right?
That's fun.
Yeah. And then having a client who is really a collaborator and who you have to keep up this collaboration, right? For this strategy to play out successfully, the collaboration has to be ongoing. And then, of course, and this reminds me of when I did the firefighter case, and Bob Demmons, who's the head of the Black Fire, much smarter than me, having a client much smarter than you who got more than you even asked for. Yeah, so, I mean, it's really, I think, such an illustration of taking apart that the normal, I'm going to file a lawsuit, I'm going to be on my horse, and I'm going to win, which is why, you know, I know we love to talk about Fred Korematsu. I wanted to talk about the tenure cases because it's such a rich illustration.
Can I say one more thing?
You can say many more things.
No, this is quick because most all of this is written in that huge, long essay.
I just read it, and it didn't take that long.
Well, you're smarter and faster reader. It's called Guerrilla War at UCLA. And the title I use is because what we needed to do to fight that type of huge power, you got to wage an asymmetrical warfare. Right. And people all over the country have done guerrilla wars against colonial powers. And so those are the type of concepts. You need to be creative, figure out your levers of power, and then exercise those. And you got to time it at the right time as well. And to create that point where you have maximum leverage, and that's when you could possibly negotiate or win what you want.
Yeah. Great example. You want to talk about policing in New York City?
Yes, let's do it. But I just wanted to say, just briefly, that I'm sitting here reflecting on all the lessons learned from everyone who's spoken. It's sort of breathtaking in some way that Jerry can bring all of us together, first of all, and that his ideas are so translatable and transferable in so many contexts.
Right.
And I actually use excerpts of it in my clinic seminar because the questions that you posed, Shauna, are so insightful and so important as we think about the future of public interest law, social justice lawyering, and the book has so many gems in it. Even just like 4 pages, you can just tease apart all of these really complex questions, and it's an excellent tool. So, just wanted to shout that out again. So let me just set the stage for the case here. So, I was asked to speak about the Floyd versus New York City case, which is the stop and frisk policing case in New York City from now a decade ago. I just got an email requesting a contribution to attend the 10-year anniversary of the court opinion, and it was just a reminder of how far we've come, but how much has stayed the same. And so let me just say that this is the case. We know about this case because there was a trial, there was a really aggressive media strategy, there was this tremendous judge who would write these wonderful opinions and cite lots of black scholars about policing, and it was great. But the history is a case from 1999 and 2000. Around the time some of you might remember the street crimes unit and the Amadou Diallo shooting and all of these other incidents, the Abner Louima, these names might ring a bell to some of us. So that was the first case that was filed, and it was settled. And when it was settled right after 9/11, because so there was this height of this policing movement in New York City that was black-led, and then there was 9/11. And so, the pro-policing fervor just gave the police so much leverage and gave the city a lot of bargaining power. And, I don't know, I wasn't there, but my sense is that it sort of forced everyone's hand in terms of a settlement. That was fine. They did get rid of the street crimes unit. They had some monitoring. Data was the big thing that they got out of the settlement. But there wasn't any independent monitor or any kind of long-term sort of the things that we would think of as the new wave of how you monitor these sort of big police cases. So then, you fast forward, this case was filed again, the second case was filed because it was sort of I think the community came to the organization and said, you've been asleep at the wheel, and this is still going on, and, you have this data, we have this data, you need to do something about it. And so the lawyers, I think, maybe begrudgingly even, try to go back to court, reopen the case, this new case is filed, it's a whole story about that. But we're still in this era where there's a lot of momentum around policing, right? And so then as we continue with the discovery, and then this is when I came on the scene, we continue this discovery process. We also are building, this was one of the things that I really tried to do in my role, was really building this coalition, rebuilding, I should say, not building, rebuilding, putting back together the pieces of this long-standing, decades-long coalition of folks, multiracial organizations led by people of color, political groups that were fighting against the police in New York. And so, and you can see some of the remnants of this in the way the case is put together. The named plaintiffs, the main plaintiff, his name is Desaw Floyd. He was a leader in the Malcolm X grassroots movement. 3 of our 4 named plaintiffs were from MXGM, and that was intentional. And so a lot of the people that I talked to once I joined it didn't really phase it. I didn't think of it even, honestly, when I joined the organization, because I was coming from legal services. I was always sort of, I think similar to Gina, went to law school because I had seen these moments of organizers, as a youth organizer, and lawyers kind of collaborating, and said, I think I want to go to law school. I can see the value in this, and there's a moment in political movements when you need a lawyer, and I thought, I think I could do that. It's very difficult to say that and actually do it. But so, so I left the job that I was doing because I had got all this training on how to go to court, how to do all these things. And then I was going to the Center for Constitutional Rights, which is known as this sort of movement lawyering, organization that we have a political education department, we have communications, we have lawyers, and especially in the policing work, kind of looked to as the organization in New York City that will kind of go to bat and do the hard cases. And so it was an honor to be able to work on that case, and it was really an amazing learning experience. But I think I guess just to answer some of the questions and not romanticize things, as sometimes we have a tendency to do. I think representing individuals from the Malcolm X grassroots movements, facing the law firm partners who were co-counsel on my case, saying, we have to put on one of these plaintiffs first. We're not going to put on our statistician. So a lot of people will put on their statistician first, because then you kind of prove the case through your stats. And we said, no, the story was most important, the narrative was most important. And so, so there's a lot of infighting, internal, not fighting, but just conversation when you are trying to do something from a, movement-centered, community-centered way, and not just a client-centered way, right? I think there's this difference in the way we would think about that. There's a tension there, especially because the organizational plaintiff, which was very radical organization, was dismissed from the case. Oh. So we only had individuals in the case. So the court had found that they lacked standing. That's a whole other thing. So then, so I'm sort of this person in the room with all these mostly men saying, wait, we gotta do this, we gotta do that. And so it was hard. I was one of the youngest, most junior attorneys on the team. But I think mostly people, as soon as you said it, people got it, right? Especially within our own organization.
But what about with the firms who have a traditional approach to litigation and who probably have their own deeply embedded biases about putting on someone first from MXGM? How did you deal with that?
Yeah. So we took a very strong stance that we were lead. And in fact, our co-counsel arrangements, which I'm going to give folks a hot tip, is we actually had a feast, like a donation pro bono award fee structure. So they had to give their fees back to us. And so we had a very astute legal director who negotiated that agreement. So and so so we just, you know, throughout the whole case, yeah, sort of asserted our role in that way. And I think mostly we had great people we were working with who would defer to us. You know, that was one thing that was really helpful. So, so we had this tension around what was the narrative we're going to tell, what was going to be at the center, those kinds of things. I think the other thing that I wanted to mention, just in terms of the difficulty, is that when you're doing, it wasn't just me, but there were others too, but when you're doing this sort of grounded community-based work, it's your second shift, right? So people in firms talk about pro bono being their second shift. This was our second shift. So we have to do the briefs, have to do the litigation, discovery, and then you got to go to the community meetings at night and find time for all those coalition calls. And it's not as respected, even in, you know, these organizations that have these values that I do think people believe in. But, you know, there's a sort of tactical role that people think that lawyers should play. But in order to do that well, and from this perspective, you have to be on the ground as well. So there's always that sort of unforgiving time pressure. And then just in terms of the narrative, the other thing I wanted to say is that that was something that was really important to us. And so we had a communication strategy. Honestly, we didn't have to do that much, especially anytime there's a data dump, the New York Times is calling us. I mean, that's one benefit of being in New York. And also, when the trial got started, it coincided with the mayoral election, and so it created the opportunity to be on the front page almost every day during the trial, and the trial lasted for 3 months. Wow. So we didn't have to do that much. You know, the media, we didn't have a jury, but that was where the media, the scrum was, and so it was basically like, felt like a jury because you had all these journalists in the jury box. But the narrative work was really important, and so I'll just point out the tension with some of that, right? So the overarching narrative of stop and frisk in New York City was that it was young black men that were facing the bulk of the stops and frisks, and I think by and large, like, that's not untrue, but there's a large number of Latinos that were stopped and frisked. There's a lot of women. There were a lot of LGBTQ. There was like a lot of vulnerable folks that were getting stopped and frisked. And so because we were in coalition and partnership with many groups, that was something we were getting challenged on, right? Like, what are you doing to make sure you're really making sure the story is inclusive? And I don't like the word inclusive, but that it's representative of everyone who is facing the practice. And so the New York Times called me at one point, and they said, we want you to help us do an op-ed on the experience of someone who is stopped and frisked. And so they were like, they did, maybe I shouldn't say that I ghostwrote, but like they were like, you should ghostwrite something with one of your class members or clients. Or that was my proposal, was to do that. I don't know what they really wanted, but that was what I proposed to them. So they said, okay, that's great. So the first person I brought them was the one Latina woman who was going to testify at her trial. She was queer, and she had a really compelling story where the officer stopped her in an area that they thought she was a sex worker, and they pinned her up against the van. I mean, I thought it was really representative of a lot of the problems with stop and frisk. It was a very aggressive stop, and one of the officers was a black woman, which I think we really wanted to demystify this whole idea that if you diversify the police force, that you're going to get like good police or something. But they responded and said, no, this is not what we want. This is not a typical story. And so, I mean, the story that got run, and Nicholas Pert, I mean, you know, it was a really, really, really compelling article. It did really change the narrative and change the way people viewed stop and frisk, because you had a human story. He was a young person. He took care of his disabled sister. And so we were able to get in all these other facts that showed, you know, that really humanized the experience, because a lot of people in New York felt like, oh, this is just a minor inconvenience. I had a judge say that to me once. And so, you know, there's a way in which the narrative shifting is important, but just understanding that our role and the tension that's there when we're trying to do this sort of representative work. Is that okay?
That's great. Does anyone want to comment before I push out another question on what's been said so far? Okay, so most of this work we've talked about, well, Gina's is ongoing. but a lot of it happened before COVID, before Trump, before the onslaught of restrictions on books and speech, and the unbelievable amplification of negative stereotypes of people of color, right? So now we're in 2023 where that is our landscape. And many of your clients I would describe as members of our society that people want to put in negative boxes or out of type. I mean, I remember when I was desegregating the fire department with the Asian Law Caucus, the city attorney turned to then Ed Lee, the late mayor of San Francisco. Why are you here? Don't your people want to be engineers?
Oh, no.
You know, so your client's definitely, yeah, Louise Rennie. Your client is definitely, you know, outside what an Asian professor is supposed to do. We know how black and brown men are perceived, whether inside the police department or outside, and we know how people who are facing about to be unhoused are perceived. So given how our communities that we're trying to collaborate with and bring transformation to are perceived, what strategies would you devise in this climate that might be different from what you did in the past? And I won't go down the road. I'll see who wants to take it first, and then I'll go down the road if no one wants to.
I'm happy to take it first, and I'll probably be the least radical, and I apologize for that.
No apologies.
After my stint at Maldiv, which was the nonprofit doing impact work, it was just really unsustainable for me because of the hours and the stress and anxiety. I went over to the Department of Civil Rights, which is a state agency where we also litigate, but in a different context. And I think that there are some benefits that allow you to kind of bypass or deal with some of the things you're asking here, Shauna, that I think you kind of have to address on a personal level, and I'll give you some examples. So the it used to be called Department of Fair Employment and Housing. It's been rebranded as the Civil Rights Department. And by the way, I worked there 5 years, and I'm no longer there, so I can speak about my experience while I was there. So there you have the people of California, they file these administrative complaints. And these administrative complaints in employment are necessary to exhaust your administrative remedy before you can go to court and have the ability to file a civil complaint. So it's kind of like, you know, you can think of it as just like this technical little step. But what happens is a lot of people have lawyers and representation, and they have big cases, they're big damages, big emotional distress. So what they say, is they just click a box that says, give me my right to sue, and I am going to go file my own lawsuit with my fancy law firm. And that's really great. We want them to go because we don't have the capacity to process everything. But there's other people that don't know any lawyers. They're not, quote unquote, fancy or sophisticated. They have a job where they make, $20 an hour, and they want us to investigate it. And so there is an investigative arm, and I didn't work there. I worked in the litigation side. So when things go through investigation, and if there's a finding of cause, our department has discretion in the legal arm to say who can take this case, right? There's more cases than you can possibly take, so you can find cause and close the matter and give them the right to sue and say, we think there's something there, you should go get a private lawyer, or we can give it to ourselves. And so at least while I was there with John Ishinaga, our chief, they kind of ask you, what are you interested in? What kind of cases do you want? I was like, well, I really want some people really want to focus on disability, some people want to focus. And so I had a pretty good stream of cases representing lower wage Latina women caught in tough situations who there's probably no CELA lawyer in town that wants to take their case. You know, if you have, or not even Maldiv would want to take the case, because you know, we were representing certain types of people at Maldiv, or seeking injunctive relief where, you know, you were looking for standing rather than like, you know, so it's just different situation. So here, sometimes you have the opportunity as a government lawyer to say, look, I'm getting my salary the same no matter what. I don't get bonuses. And so all I have to do is do a good job, and I can get someone a victory of $75,000. And that's life-changing. And I was able to do that on a steady stream for people that, even sometimes $35,000, and that was also life-changing. Having the ability to select cases out of a plethora of all of these cases have potential merit, and that, I think that's a very unique situation, because of the reality of a plaintiff lawyer is that you do want to have your bread and butter. You have to keep the lights on. You have staff, and sometimes, you know, there should be no tie-in to your attorney fees. Your attorney fees should be what they are. But if you have all these attorney fees that are very voluminous, and you bring in a jury verdict or a bench verdict of $55,000, the other side might try to attack the amount of attorney fees you can get, and you don't want to have that fight. There's constitutional thresholds and tie-ins and proportionality, and as a government lawyer, I don't care.
Right, and you don't have that tension between your client's best settlement and you getting paid.
Yes.
And, right, and you can take on the people who aren't the most attractive clients.
Correct.
Right.
And so, yeah, I would say that, like, I was able to represent a steady stream of that middle segment of the population that normally would, I don't know where they would go to get represented. And the other thing is, depending on who your chief is, you don't necessarily need to take all the attorney fees. So you can negotiate in lump sum. Like, let's say you litigate some and you're going to negotiate. This is what you think the economic, emotional distress, attorney fees are all together. But in the end, you can allocate it as you desire and cut yourself short so that the state does get some back, but it doesn't have to be the full amount.
Exactly. Dana, you want to talk a little bit?
Sure. So one thing I wanted to mention, just also about the last question, is that about the race claim that I forgot to, we wanted, you were saying, make sure you say that, I forgot to say that. So we just, you know, like, the stop and frisk case was really the narrative, the thing we were pushing was the race claim. There was also a Fourth Amendment claim, and a lot of the attorneys right before trial were like, you know, attorneys in New York and other people who do civil rights work said, you should really drop the race claim. I mean, it's not winnable. It's really difficult. I mean, it is very difficult to win a race claim. And, you know, you're going to lose. It's going to be a disaster for everyone if you lose. Don't push that. And, you know, obviously we were going to push the race claim, and we didn't really have a way around that. But I think it's interesting as in the conversation here about a regnant lawyer versus, I mean, not versus, but, you know, like in the conversation. So I wanted to point that out. So then, and also just to say the answer to this question, that yesterday in class, there was this perfect tie-up on this question where,
Tell them what you teach.
oh, okay, I teach a veterans clinic where we do, we represent homeless or housing insecure veterans in a variety of cases, and the students this semester are all working on citation defense, quality of life citations, and we have a couple of students that are getting ready to go to court and try to defend folks, and there are no lawyers in this court, so, you know, like, this is a huge service to get, like, lots of debt erased for people. You know, it's a barrier to housing, it's a barrier to employment, so that's what we work on. And then we do these big projects, and one of the things that we do in our, we're working with Anti-Police Terror Project this semester on this traffic policing project, and one of the attorneys said to me, and this is I think, a reflection that, this reflects sort of my view of the Floyd case and of lawyering right now in this moment, and he said, you know, I think right now, I'm just not interested in compromise as much, given the moment we're in. And he says, the Earth is about to implode, like climate catastrophe. Are we even going to be here? And I don't even say that lightly. And he says, we don't have time for these incremental changes anymore. And so he said, so I want your students to come up with strategies for us that are going to really we don't want any surveillance on traffic stops. We don't want any cameras. What can we do that has nothing to do with police and traffic? And that's what we want to push in our statewide campaign. So that's what we're working on. And so in the class, we had this part of the class where we talked about disability justice, critical disability theory, because we work with so many disabled folks. And then this narrative theory class where I was really trying to get them to create a storyline for their clients that a judge would find palatable. And I don't think he's here, but one of my students, so reflective, so amazing, says, I feel like these two things are very much the opposite. You're trying to tell us to write a story that a judge is going to find compelling, that twists our client into this sort of storyline that everybody's going to accept, but then we're having this critical disability conversation where we're reading this literature that tells us not to do any of that. And that is, both are true, right? And so I just say that to say that in this moment, I think that tension can't be more important to recognize and work with. How do you bring in that critical stuff in the low-level court, in the traffic court? How do you get the judge to keep hearing how bad the system is? How do you do the systemic change at the same time? I don't necessarily have answers, but I think that's the thing. And I think if I was to do the Floyd case now, I would probably think about ways to weave in more of the MXGM core philosophies, more about anti-capitalism, more about some of these other things that are root causes. So.
Any reflections on this?
Yeah, it's just reminding me of being in critical race theory with Professor Carbato here and him asking us, so it's like the period of time in this country when you have to be white in order to be a citizen. You have a Mexican client. They're asking you to plead for citizenship. Are you going to argue that they're white in front of the court? And I think that just to spin off of what you're saying, I think it's also a time where we have to remain adaptable. I think my specific context is a bit difficult because really I'm working along lines of class, and there's always, just we're forever talking about class versus race, blah, blah, blah. But it is true that people who are evicting tenants are not all white, right? It's not as though there are clean-cut racial divides that we can just sort of pin our story on. And then I'm constantly thinking about my CRS education actually while I'm litigating, because the point is that it's a social construction. And so it's flexible and it adapts with whatever slice of society you're sort of angling at in that moment. So what does it mean to be brown? And what does it mean to be brown in this case where your landlord is always brown? Because, for one thing, Latin America is huge. Mexico is huge. There are factions. I've become aware of this the more I do this work. And everyone's going to be wearing that badge of race differently or carrying the weight of that differently. So I think sometimes it turns into us acknowledging in the room, okay, this is probably about racial discrimination, discrimination based on skin color because somebody's more indigenous and this other person's from northern Mexico who is their landlord, who has more resources, who is lighter skinned. The judge is not going to let me bring a racial discrimination claim because the judge sees them as both brown. So what does this mean, right? So how can we figure out a way for this person to tell their truth before the court and still speak of their suffering in a way that is true to them and craft the defenses in the case that it matches that? Sometimes it looks like disability discrimination. Sometimes it looks like gender discrimination or finding some way to fit it in. I don't know whether or not not pleading the racial discrimination case is doing them a disservice in that moment, but it would be really interesting to talk to other practitioners who struggle with this.
And especially given the example you gave, and you have a fact finder who may have no understanding of the complexity of the Latina community, and so are you by pushing the race case already turning that person off before you even get into the facts of your...
Yeah, I do, but I find myself worrying a lot more about the judge than LA County juries in downtown LA, to be quite honest.
Really?
Every time I've had a jury in state court in downtown LA, I'm just like, but everybody's a person of color. It's gonna be a party. So yeah, I think just my specific material context are more forgiving in that.
I was just shown how little time we have. And so I want to switch gears really quickly, especially since there's so many students here, and ask the panelists to talk a little bit about doing the work in different contexts. So the constraints of doing it in a law school. The Asian Law Caucus was really, before Jerry wrote his book, founded, and he's one of the co-founders, with a rebellious base. I remember being a law student in the 70s. I know I'm old. And yeah, I saw that side glance. And
You look great.
my colleague Bill Tamayo came back from a summer at the caucus telling us about the community-based approach, because that was the language he used, and being just so excited. So talk about the comparison of that and then working in a private law firm. I know you've already talked a little bit about the collective, but if you want to expand, and Martha, you in some ways have had the breadth of different kinds of institutions, even different kinds of governmental institutions. So I think I'll start with you, Marta, on this one, and then we have to do this quickly because I'm running out of time.
So I will say that I currently work at the California Department of Justice, and I am not here in any official capacity. I'm here solely as an individual. I do not speak on behalf of the Attorney General or the Department of Justice. That is actually a requirement before I speak. It's in my policy, I have to say that. So what I do now is more distinct from the Department of Civil Rights. Department of Civil Rights is basically litigation on behalf of the state, for the state, and on behalf of the person the aggrieved person. And so you're still doing somewhat traditional litigation. I will say that one of the best things about that is the ability to get affirmative relief. Like, you implement a monitor, you have a period of, you have terms. It's not just the relief it's not just the relief for the individual. It's also going to be changing policies, training, monitoring, evaluating, reporting, and sometimes hiring a third-party monitor that they're paying for in order for us to ensure that there is compliance before they're off the hook. That part is fantastic because at Maldiv, you could only get that through settlement agreements, and those are very, they're less ideal because you have to go through this whole entire litigation cycle, and it's all just sometimes all about politics, and you're employed to the political system and people's political acts, whether it's like, we're going to, do the, so in a sense, you're in government, you don't have to go through a 1983 claim or some constitutional claim. You can bring affirmative relief for every single case that you have, however small it is. And especially because the FIHA protects, we represent tenants and fair housing. So they don't, by we, I mean, the Department of Civil Rights doesn't do like landlord-tenant disputes, but it involves like, I was denied this apartment because I'm queer, and my landlord's really Christian, he doesn't like my identity, or, I have a disability and I require this emotional support animal, my landlord says I can't have it. So those sorts of cases where the landlord, where we're like, well, how many properties do you have in the state of California? Let's see where they're at. Okay, well, let me see all your policies and all of them. Oh, you don't have any policies. And well, how many people do you have with, Section 8? Oh, none. How many have applied? So you can kind of get to a larger relief with a person within the state of California in that way. And that's nice. And now in my current job, which is the Department of Justice, it's not complaint driven, and it's not driven by people's individualized complaints. It's more based on the Attorney General's authority to suss out constitutional and statutory violations. And so there's no limitation on jurisdiction and power and authority, which is really nice. Federal claims, state claims, everyone, you want all sorts of things. And so I won't say much about that, but it is basically just systemic work.
Sure. I've worked at both nonprofits at the Asian Law Caucus for a couple of years. We've talked about that. I went to a private firm, and the dynamics, I guess, were very similar. I mean, we did everything pro bono, whether it was in private firm or the Asian Law Caucus. But the Law Caucus, we had to beg for funding, and we were lucky enough to get a certain kind of tax exemption so we could charge small fees. We also only got paid half of our salary. I taught part-time. And so we were actually, and it was a different time than now. We didn't have student loans. My law school cost $241 for a whole year. You could buy a house for $1,000, just about. I mean, so we didn't have the kind of stress that young folks have now. What we did have is an environment in 1968 to 1971 where we were, and Jerry could speak to this too, we were driven to try to change this country. We wanted this country to live up to its rhetoric. So money was not as much of an issue at all, even though, of course, we had to pay enough to live on and rent. The same dynamic occurred in our private firm. Although there was a little more imperative to make some money, but at the same time, we felt just that, you got to feed your pocketbook by taking fee-bearing cases, but you got to feed your soul too. And so, you can't do one without the other in terms of the way we felt about practice. And of course, I feel very different now. If you have 2 kids, things change, and not so much that I'm mercenary, but I feel that that passion that drives you, that has Gina doing what she's doing, and everybody here, is something that if you could keep that, and to see this group of people is remarkable to me. And to know that one of my really good friends, Jerry Lopez, started this whole concept of rebellious lawyering. And see Bill Hing over here, my neighbor from San Francisco, who's also one of the rebellious lawyers. I mean, it even draws movie stars, whom I won't name, but is here. And but it does have a huge significance to me to have that kind of support from each other, to know that other people are doing what you're doing, and importantly, to export that information, which is what this whole conference is about. Export these ideas, so that is the one regret I had is I wasn't able to replicate some of the cases I've done because I was too tired after these cases. The only thing I did was write this really long article. Figuring I could just export that article and then I don't have to talk anymore.
Do you want to talk about law school setting, doing work in law school setting? Well, maybe I'll talk about doing work in law school setting. I'm retired. Tenured and retired. I remember, and my dear friend and colleague, Escanio PMLA, is here. When Escanio had the idea to start a clinic doing social change, we had been doing individual representation in the area of employment, labor, wage and hour, housing, and disability, social security, SSI cases. And then we wanted to branch out and get into work that was more transformative and show our students the different ways, different strategies played out, and to collaborate with people who are doing community organizing, legislative or policy reform, some impact litigation. And so we developed this course, and Escanio was really the brainchild behind it. But I had to take it to the faculty because I was on the tenure track. And at that time at UC Law, formerly Hastings, we still had a few of the over 65 members on the faculty. And one of the constraints was, I'll never forget, I can't remember what his name is, I can picture him, standing up and saying to me, well, are you going to represent both sides? Meaning, am I going to take on corporate interests? And I said, no, I think they have enough lawyers representing them. Well, if you're working with landlords, tenants, I think you should be working with landlords, and on and on and on. And there were enough of the faculty, and these days, clinical education wasn't the most popular thing at our law school, but there was enough of the faculty for this course to squeak by, right? And so we get this course going, and the students, for the most part, were just wonderful. And we built some really great partnerships with community-based organizations that we could work collaboratively. And the campaign against affirmative action was on. And we were just going to do some, basically what I would call educational fora and a little organizing around it. And I got called into the CFO's office. And which, don't get me started why he should even have the right to question what I'm doing. But, and it wasn't until I could point out that, UC Berkeley's doing work like this, UCLA's doing work like this, that our work on 209 wasn't shut down. And so all that is to say there are some positive things about working at a law school. For me, the students, one of the biggest plus. You're often also in a position where you have resources that you wouldn't, and you don't have to fundraise for those resources, but you do have then the constraints of getting courses past peers who may not really even understand what you're trying to achieve, and a board of directors putting pressure on your administrators because of the work that you're doing. So there's some pluses and minuses. So I'll take you off the hook for that. Okay? But do you want to talk a little bit about working at?
Yeah, I think the main thing here is just like what's the culture of these different types of settings, and what are the limitations and what are the opportunities. And I do think that in a law school, the benefit is you don't feel like you have to have this high volume. Generally speaking, that's not the goal of a course. You give students opportunities to do smaller things or bigger things, but you can be selective. I do think there is a tension though on this funding issue that I thought I was escaping by coming to a law school, because this is going to be a controversial statement, but I do think that, to me, I think that law clinics should be funded through the university, through the law school, and that's not really how it's happening now. I'm not just speaking about here, not talking about UCLA, but across the country, there's a lot of competition with nonprofits and whatever for
Funding.
grants and staff lines through that. And I think that's in tension with some of the educational mission of law clinics, and I think, I don't know. I think, like Gina, would love to have conversation with folks about that,
Right.
because I do think
Yeah. There are many clinics where they have to fundraise for a big portion of their resources. Gina, you said something earlier that I thought was interesting, that you said we're in a 501c3 for political, just for tax purposes, but we really operate as a collective. Can you talk a little bit about operating as a collective and your thoughts of scaling it? And with that, I'm going to say a personal note. I, once upon a time, worked for a nonprofit, Equal Rights Advocates, and during the interview, the executive director at the time told me, we're a nonprofit, but we're somewhat hierarchical, and we have an executive director and a legal director and blah, blah, blah. And then I'd go to staff meetings, which lasted forever, and everything was done collectively, and I found it very frustrating because I had work to do, and we were, there are 12 of us talking about ordering office supplies. So I'd love to hear your thoughts on that, and
Yeah, sure. So we have fashioned ourselves into a consensus-driven collective. So all of us have our official position title is just collective member. And we train all new people on the process of making decisions by consensus. This doesn't mean that all of us have to decide which color Post-its to buy, but just that everyone knows what their role is and that we are in acknowledgement of the fact that like our relationships to each other are also part of the work. Right. It wasn't an easy road to get here. I think this might be the last question, so maybe this is where I should share the story about 2021. So while waiting for this conference to happen, there was a huge upheaval in my organization. There used to be 4 attorneys, including myself, who used to work there. And then I was the only attorney of color, and then all the white folks left. They left at the same time. They abandoned all of their cases. They abandoned the community, and they had run the nonprofit into the ground in terms of the money as well. So I feel like I've aged like 20 years within the past 2 years. I won't share all the gory details, but suffice it to say we got through, and we were able to rebuild with people whom we trusted and with people that we could say, like, we want to be horizontal with each other. Like, we want to see each other eye to eye. And we've started really taking the culture piece of it into strong consideration. And I think also one thing I want to share specifically to this room is that in that moment of crisis when everyone else left, it was heartbreaking for me personally, but also I think I realized in that moment that my role had shifted to acknowledging the harm that was done, not only to me, but to the people that these folks had left behind. And then realizing that, like, hey, if I'm a team player, if I'm on the same team as these people in the community, that means I want to be here and shepherd who I can through this conflict as well, through this time. So repairing trust in the system, not that we want people to trust the system, but repairing trust in attorneys, repairing trust in the organization, that really became the next struggle. And it just meant that I was redialing what the goal was for that year, right? What the goal is for the next few years. But I do think that containers matter, and I do think that in terms of scaling, I really don't know. I really don't know. We have dreams. Like, we have dreams of expanding to, you know, at least like 10, 15 people, right? And I think I can see that system working then. But I think, like, I think it takes acknowledging that it takes a rising tide to lift all boats, and that everybody needs to be on the same page about acknowledging that the differences are not really what matter, right? What matters is whether or not we're able to work through them and work despite of them. So
I was just given the 5-minute warning, so I'm not going to ask another question. I'm just going to ask of my panelists if there are any final words that they have.